During the trial, the jury would be able to hear outside noise and influences. It is a deliberate, ongoing, strategic investment to reach the potential jury pool.
I like talking. I like to reveal the truth.
It is round 2 starting today for defendant Karen Reed. Her retrial for the death of Boston police officer John O'Keefe kicks off in an hour. And we've got some different attorneys facing off in opening statements. So who will steal the show in Dedham? Plus, how was Cult Mom's closing? Well, we're in a verdict watch right now for Lori Daybell's homicide case in Arizona, and our legal eagles will grade her as lawyer. Also this hour, Bushy eyebrows allowed in. We're spotlighting the key rulings issued ahead of the trial for defendant Brian Kohberger. And all 3 defendants now heading to trial in the case of the murder of Crystal Rogers. Now this despite an effort to delay the case for one of them. So did something go wrong here? We'll talk about it. It's all coming up next for you right here on Opening Statements. Good Tuesday morning to you, my friends. I'm so glad you are here. This is Opening Statements, and I'm your host, Julie Grant. I'm fighting a little bit of a cold, so please forgive me. Let's get it going. Get that tea. I've been having a lot of tea this morning instead of coffee. Coffee, whatever you like. It's time to kick things off, as we always do, with my opening statement. She said, "I was praying for my husband." Lori Daybell claims that she didn't plot and plan to murder her husband, Charles Vallow, but instead she claims she prayed for him. So, did those prayers come when she was cheating on him? She was meeting up with Mr. Doomsday in hotel rooms? Or did they come when she lured Charles Vallow to her house to encounter her brother with his firearm? Or maybe the prayers came when she took Charles's phone away from him so he couldn't call for help after he was shot and bleeding out. Was it then that she prayed for her husband? That's just a little bit of what I would have said on rebuttal if I were prosecuting her. I would say to that jury that you don't get to commit murder and then hide behind prayer. No, not how it works. You want to commit your sorry, cult-loving self to a lifetime of murder? Then leave the Lord out of it. I'd respect this woman more if she would just admit that she's a sociopath. The evidence that Charles Vallow was set up to be murdered is undeniable. And Cult Mom's behavior is sociopathic. You know, once upon a time, my friends, I had my doubts about this woman. I thought that she might be crazy because nobody in their right mind would kill their own children, right? Nobody in their right mind would commit 3 murders and not show a bit of remorse for them. Nope. Here we are, sociopathic. We're here with murder number 4 hanging over this woman's head. I pray to God that justice is served for the 4th homicide in this woman's life. Charles Vallow was a good man, and now he deserves for justice to be done. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
How do you feel about Hank Brennan planning to use your interviews in his opening statement?
Come at me.
That's what your dad said.
You sound like your dad.
I may have seen it. I would not have said anything that I wouldn't say again.
In Massachusetts, defendant Karen Reed back for round 2. Opening statements in her retrial kick off this morning at 9 a.m. Eastern Time. Court TV will take you there live when it does. In Connecticut, we've got jury deliberations resuming this morning in the murder trial of Jose Morales. They're going to pick back up at 10 a.m. Eastern Time. And in Texas, we've got defendant Brad Simpson in court for a motions hearing. He's accused in the murder of his missing wife, Suzanne. Now, court begins at 10 a.m. Eastern in that one, so we're going to watch that one for you and then report back on any major developments. Now, let's turn to our top story. We're in a verdict watch this morning in Arizona for Lori Daybell's trial. Court TV legal correspondent Kelly Kraft has the latest.
Good morning to you, Julie. Jurors will be back at the Maricopa County Courthouse shortly to deliberate the fate of Lori Daybell. On Monday, jurors listened to an extensive closing argument by the state and a much shorter close by Daybell, who told jurors, quote, "I did not commit this crime."
She's walking around the house holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother, Alex, could shoot him.
Daybell is accused of conspiring to murder her fourth husband, Charles Vallow.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime.
And Julie, jurors will be back here at 1:30 p.m. Eastern. That's the latest from here in Phoenix. I'll send it back to you.
All right, our thanks to Kelly Craft. So was it a tragedy or was it a crime? And how do you think Cult Mom did delivering her closing arguments? Let's bring in our wonderful guests this hour. I'm so happy to have back on the show attorneys Anton Bell and William Ehlenfeld. Great to see you both. William, I'm glad we didn't scare you off from last week. First time on the show last week. You were fantastic, and Anton's one of our old friends of many years here. So great to have you both here dissecting what went on with Cult Mom. And let's start with grading. We want to put you both in the position, as you're both extremely seasoned as attorneys in the courtroom and as prosecutors. How did Cult Mom do with her closing argument? We took a poll on our Court TV YouTube chat. I wasn't very generous. I gave her a bad grade. So feel free to do whatever you think is appropriate here. Anton, start us off.
So she was articulate, so I will give her at least a C minus because, and the reason I start with a C minus is because anyone who represents themselves is a fool. And so you can't get a passing grade. In law school, you have to get at least a C minus. So C minus.
We're going to start there. Yeah, let's set that bar at average, right? Average and slightly below. Hi, Anton. William Ehlenfeld, what do you think? What would you grade Cult Mom?
I would give her a C. And I was talking to my daughter, who's an aspiring lawyer, and I told her that if she happened to be flipping through the channels and were to come across the coverage on Court TV of Lori Daybell conducting examination or giving her closing argument, you might think for a moment that she actually was a lawyer. And I can tell you from all of my years of experience in state and federal court, I've seen worse. I've seen lawyers get up there and actually just read the closing instructions that the judge had just read moments prior. And so she didn't do that. She took some steps to criticize the investigation by the Chandler Police Department. But all in all, she would have been much better off had she actually had an attorney, a real attorney representing her in this case.
William, thank you for that. We're going to recruit your daughter to come on Court TV once she becomes a lawyer. That's awesome. All right, I want to show you both a clip. This is where Cult Mom's legal theory is really emphasized. She's talking about how it's a tragedy, that shooting was never meant to happen. It was a self-defense shooting, just awful. And she prayed for Charles. Let's watch.
The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy.
Well, the family's been torn apart, as we know. Anton Bell, what do you think about how she is framing this for the jury?
I love it. I'm here for it, because here you have someone who has committed murder at least 4 times, at least alleged 4 times, and you're able to articulate the facts in a way that it tries to favor you. Now, here's the thing, Julie, I loved your opening argument because you nailed it. You said it correctly. She is a sociopath. And when you are a sociopath, you are able to truly be the smartest person in your world. And she tried to frame the facts in a way that made it seem that she was innocent. And for those who are watching and wondering, well, how can a sociopath do that? Remember, Ted Bundy, who went to law school, was a sociopath. So you actually have good evidence and a track record of that.
Right. She does remind you of Ted Bundy. That's a great comparison, Anton. You know, because we've been saying, what is it about this woman? You know, she's very pretty. She's got that sweet, disarming voice. She's actually sometimes likable the way she talks. She's very easy to be around. And, you know, much like Ted Bundy, nice looking, great conversationalist. Yeah, here we are. Oh, my. And then how about the state, right? You know, I think we all know how a prosecutor's biggest fear, right, is losing to a pro se defendant. Has this team in Arizona done enough? William, I want you to assess them for us, please. I'm going to play a clip here. This is from rebuttal. This is the state on rebuttal. Here we go.
Execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy.
Okay, William, what did you think of the state of Arizona here and overall in this one?
I think they did enough, Julie, to answer your question. They did enough to meet their burden. This was a difficult case. Fortunately, they had the digital evidence. Fortunately, they had the text messages that Ms. Daybell sent, and they were able to introduce those in which the conspiracy really was proven there. It would have been a tough case to bring without that evidence, but they took that, they weaved it in with the other testimony, and they were able to meet their burden of proof. I think the other thing that they had going for them is that the defense didn't put on any evidence. And that certainly helped because Ms. Daybell was sort of handicapped in her closing argument. She was not able to say very much that wasn't objectionable. And of course, the state made a number of objections during her closing argument. By not offering her own testimony, by not offering any witnesses, Ms. Daybell was really limited in what she could say. So the state was able to take advantage of that. They're able to point towards the text messages that were sent that were very damning and put together enough evidence that will allow the jury to find Ms. Daybell guilty today, I believe.
William, great points. Speaking of that jury, we all were stunned, I have to tell you, and that's what our team said, that everyone in the media was stunned. We thought the jury was going to be deliberating last night. Instead, they wanted to go home, be with their families, eat their dinner, what have you, and they're going to start today. So how long do we think the jury's going to be out? We love to do predictions here. Our Cordies love it. William, you're going to get to know our Cordy family. They loved you last week. It's not very often we have a former U.S. attorney on the program. And so our Cordies, we like to guess and kind of estimate how long we think the jury's going to be out. Will this be a fast verdict? Anton, what do you say?
Absolutely.
Yeah.
I give them less than 2 hours. That's
a good prediction. William, what do you think? How quickly?
It depends if they follow her request that they watch the entire video of the statement that she made. I don't think they're going to do that. And so I have to go with Anton. I think it's going to be 3 hours or less.
Yeah, that's good. Good prediction, you two. I'm with you. I think it's going to be a quick one here. Our Cordies are going to weigh in, and we're going to hit our first break of the hour. William Ehlenfeld, Anton Bell, stand by for more questions, please. We're going to hit a break when we come back. Here's what's coming up on Opening Statements.
I've been ready. I have no choice but to be ready. I feel strong. I've got an amazing team, and I'm anxious. Jonathan. Yeah.
How much input do you have on the opening statement?
It's collaborative all the way around. Alan owns it, and he's always open to input and layers more of input.
We've got defendant Karen Reed getting ready to be tried again in Massachusetts. We're asking, with different lawyers delivering the opening statements this time around, who's going to steal the show? And bushy eyebrows can come in. We're breaking down the key rulings issued ahead of the Idaho student murders trial. Be right back.
Is Karen Reed a killer girlfriend?
She's guilty.
Or the scapegoat in an elaborate cover-up?
Karen Reed was framed.
Karen Reed is accused of murdering her police officer boyfriend.
And stated repeatedly, I hit him, I hit him.
She may end up taking the stand.
Her first trial ended with a hung jury.
They haven't proven anything. Will a jury finally agree on a verdict?
We know who did it.
The Karen Reed murder retrial. Live coverage today on Court TV.
Welcome back. We're minutes away from opening statements in the retrial of defendant Karen Reed. And this legal rematch is what's trending in true crime this morning. I'm showing you a live look at the courthouse in Dedham, Massachusetts, where this case is taking place. Reed is accused of second-degree murder for the death of her boyfriend, Boston police officer John O'Keefe. And while we don't know what's about to happen today, we know we're going to be seeing some different faces. This year, Special Prosecutor Hank Brennan is leading the case for the Commonwealth, and he and Karen Reed's defense attorney, Alan Jackson, will be facing off during opening statements. This is going to be a lot different than last year when we saw David Yannetti and Adam Lally facing off. So we can look back last year and maybe we get some clues. Take a look.
Different people from within the pickup and different people from within the house observed that Lexus SUV in one location, pull up a little bit further, and then pull up a little bit further till it's in the area of that fire hydrant, of that flagpole, where Mr. O'Keefe is located the following morning. No one ever exits that vehicle. There are no footprints around that vehicle. From all of those people within that house that evening, none of them at any point in time observed John O'Keefe come into the house. They see the vehicle out front, they see the vehicle pull away, and they just assume that they left and that no one was coming in.
All of them leaving the residence. Each of them walked out facing the front lawn, where the Commonwealth will tell you that a 6'2", nearly 220-pound big man in dark clothing was sprawled on the front lawn when there was only a dusting of white snow on the ground. He was supposedly sprawled on that lawn, just feet from where these people were walking when they left the residence. And you will learn that not one of these people saw John O'Keefe laying there.
So here's what we're wondering this morning. Who is going to steal the show this morning? Let's talk about it. I want to welcome in now podcaster and host of the Roberta Glass True Crime Report, Roberta Glass, and the prosecuting attorney for the city of Hampton, Virginia, Anton Bell, should be with us, but I see our friend Joseph Scott Morgan here. Hey there, Joe. There's Anton. Joe made a little cameo getting ready for the next segment with us. All right. I'm so happy to have you both here to talk about this. So opening statement's a big deal, right? The first impressions for the jury seems like it's going to look a lot different, and we know two different people are going to be delivering them. So how might that affect things? Roberta, would love your thoughts, please.
Well, I think the star, if you're going to ask who the star of the show is, I'd say the star of the show is going to be Karen Reed's own statements, which Hank Brennan plans to use in his open statements. Her contradictory and self-incriminating statements, those are going to be the star of the show, I think, this morning.
Oh, that's such a great answer, Roberta Glass. Just brilliant. Like your work on this case, you've really dug deep and done so much research. You know the case well, and these attorneys have been in it for some time. Alan Jackson since the start. Hank Brennan, he's new, but can't think of anybody more thorough than him when it comes to lawyering. Anton Bell, how do you think this is going to go when you have one attorney who's had round one already, but then a new one who is arguably one of the best lawyers in the country? So there's that.
So I agree with Roberta. When you have a statement that says, I hit him, I hit him, I hit him, how do you not use that and just really drive your point home? Now, here's the issue when you're dealing with a retrial. Normally, a defense attorney has somewhat of an advantage in that when we first try a case, they know all of the Commonwealth's evidence because they get discovery and they get our witness list, and they know somewhat of a summary of what each witness is going to testify to. Most times, Commonwealth attorneys, we will know somewhat of what the defense may claim in their case in chief if they put on one. However, a lot of times we don't discover that until they actually try the case. In a retrial, you now know what their angle is. You now know what their defense is, and now you can use that to your advantage to strengthen your case the second time you try it. So I think the prosecution in this particular case has the advantage.
Really great points. Anton, thank you for that. We have a couple clips of Hank Brennan and Alan Jackson for anyone who maybe didn't watch this one the first time around and hasn't been following it as we've been leading up. Here we go.
You see that this here, 2 teeth, if the dog's canines started here and worked their way down this way, they don't line up. They're not even. It's backwards.
It would be an odd configuration.
Well, odd. It would be like Ripley's Believe It or Not. The dog would have to have their teeth the opposite way.
No, I could see how that could happen.
Really?
Yeah.
Okay.
A bunch of witnesses who took the opportunity to describe harassment. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control.
In fact, Mr. Carney has over a dozen indictments for just that.
So what are we most anxious to see in these opening statements? Roberta, what would you say would be the one thing you're most looking forward to seeing happening this morning?
Well, I'm looking forward to hearing these statements. Now, Karen Reed has given all sorts of interviews. This is one of the defense's strategies, is to put on this innocence fraud campaign pre-trial. I think originally in an effort to get the case dropped. It didn't work. She went to trial. She got a hung jury. This time round, all those statements are coming in. They weren't in last time, and more. She's given more interviews, and all the outtakes of those interviews and off the record statements. I'm looking forward to hearing those. That's what I'm most interested in hearing.
Right. That's such a valuable thing, Roberta. And you're right. You made a great point. Little reminder, these statements were available, at least some of them. She's made more, and now there's even more available now. But the first time around, the prosecutors did not take that opportunity. Anton Bell, I know you would have taken that opportunity. What do you think about that? Do you think that might have really affected the outcome the first time?
It could have absolutely swayed the case in a different direction. When you have a mistrial, it can be one juror that is stuck on something. It can be multiple jurors that's stuck on something. I'll tell you, when looking at this case, some of my hangups. Some of my hangups is it reminded me so much of the O.J. Simpson case. Because if you remember, the defense tried to play to racial bias in this particular case. And in this particular situation, they're trying to play to the blue wall bias because you had his own doing the investigation. And so they tried to pin a number of mistakes that were made by one particular trooper, saying that, you know, his emotions clearly got in the way of his ability to clearly sort through the evidence. They wanted to pin this on her. And they said the same thing in reference to OJ, his celebrity status, him being an African-American. They wanted to pin this crime on him. Now, the one thing that they have to address, and that is the medical examiner, who said it is possible. She agreed that it is possible he could have died as a result of being hit by the car, or he could have died potentially by someone hitting him in the back of the head. That is a huge issue.
You're right. Excellent issue spotting there, Anton, and really appreciate the point you made. It's brilliant what you said. They're playing to bias against the blue wall. I haven't heard anybody put it like that, and I think you're so right. Roberta, I would love to hear your thoughts on that, dovetailing off of what Anton just shared.
Oh, yes. I mean, and not only that, Karen Reed has said that she's going to donate the extra money. She's looking to raise $1 million. I think she's raised $750,000 of the money that we know. I mean, it all seems to be unaccounted for and go into the ether. We don't know where it goes. But she said she's going to donate her money to Black Lives Matter. So, and the Innocence Project, to what I'd call, for me, disreputable organization. So perfect for her. Perfect for her. So she's attached her case to these issues, and of course pulled up this police hating of the police, the real war against the police. She's joined in on it, and I think it's really been it's been a distraction campaign. Anything to distract away from the real evidence against this psychopathic murderer.
Right, a distraction campaign. Well said, Roberta. I was watching, one of my favorite shows is Blue Bloods, and Frank Reagan always has words of wisdom, and he said, facts do not cease to exist just because some people choose to ignore them. And I heard that, and I'm thinking, just as we're getting ready to start this case, I'm very mindful of those wise words. We're going to see some facts today. My friends, Roberta Glass, Anton Bell, I can't wait to have you both back on the show. Thank you for the great insight this morning. When we come back, we're talking about the suspect's bushy eyebrows in the Idaho student murders case. Big ruling in the case against Brian Kohberger. Plus, Crystal Rogers has been missing almost 10 years now. Disappeared in July of 2015, and now we've got 2 big trials coming up in connection to her death. But the order of them has us scratching our heads. We're talking about it and what's tipping the scales.
Detectives arrested 28-year-old Brian Christopher Kohberger on a warrant for murders of Ethan, Zana, Madison, and Kaylee.
He was stalking them. He was hunting them.
You could tell there was some off about him.
A quadruple homicide in Moscow, Idaho, it's just unheard of.
This is our home. This is our university. This is our community.
These murders have shaken our community, and no arrest will ever bring back these young students.
This was a violation of everything.
This morning, we're shining a spotlight in the upcoming trial for Brian Kohberger in the Idaho student murders case, as a judge issues a few key rulings, which include allowing the jury to hear testimony on the suspect's bushy eyebrows. Brian Kohberger's defense attorneys asked the court to bar any evidence, if I could get that out, any evidence referencing, try saying that 3 times fast, bushy eyebrows, because the attorneys say that a surviving roommate's description of the masked intruder was unreliable. But on Friday, the judge disagreed, saying that the defense will have to prove their claims as being untrustworthy on cross-examination. So it's coming in. She can say she saw those bushy eyebrows. Well, how about some other key rulings from Friday? The judge also said that Kohberger's defense team can only tell the jury about his autism diagnosis if he takes the stand. His defense team did get a slight victory, with witnesses from both sides being advised to not use the terms touch DNA and contact DNA in connection to how Kohberger's DNA ended up on the knife sheath that was found at the crime scene, allegedly. So what do these recent rulings mean for the evidence already collected in the case? Here to talk about it, forensic death investigator, professor at Jacksonville State University, and the host of the Body Bags podcast, Joseph Scott Morgan. Joe, good morning to you.
Good morning, Julie.
Oh, boy. Okay, let's start with something I think that's going to be so key. Will the state get the ID from Dylan Mortensen? She said she saw the bushy eyebrows. What do you think is going to happen when we get to trial?
Well, that's one of the most definitive identifiers that we had early on, and still to this day, we think about this. And, something interesting that kind of popped up in this narrative, Julie, forgive me, Tom runs together with me, but it was a few weeks back. They started talking about these balaclavas that were found. in his apartment that he apparently had purchased these things, these masks that kind of cover all of the face, and you could zero in on the bushy eyebrows relative to this as an identifier. And look, I know that it's circumstantial, but if the prosecution can weave that in there, it makes pretty strong. It makes a pretty strong evidentiary comment relative to the eyebrows, because this is all you're focused on at this point in time. Now, we're going to have eyebrow experts, I don't know, or maybe someone that can talk about what's it like to see something in low light conditions. If that was the case, could you specifically identify someone by the structure of their face? And specifically to that point, his eyebrows in particular, what sets them apart? I find it interesting that the judge is going to allow this.
Right. Professor Joe, I thought that you might bring up the balaclava mask. So we purchased one, and we have it on a little mannequin head, I guess, here. So as you can see, but to your point, it's hard because the white kind of gets blown out on the camera, but if you see the eye, I guess I should draw eyebrows on him maybe. But you can see how that is just a small area of the face that's exposed, right? So I suppose I can see how, to a witness, if someone says, what did their face look like, and all they see is big bushy eyebrows, then that serves as a valid description.
It kind of puts an accent on it. It's kind of like, hey, look at my eyebrows right now, because you can't see anything else. And again, that's what I'm saying. The prosecution can weave that in as part of their narrative. I think that could potentially be powerful.
I do too. I do too. I would have been stunned, I've got to be honest, Professor, if the judge would have kept it out, because it's a description. It's a valid description, and we know that we don't have a full identification. She never said it was Brian Kohberger I saw. There was never a preliminary hearing where she pointed to him and said, that's the guy. No. So who knows what she might say. With respect to some of the other things, I'd love to get your thoughts on something that's been talked a lot about in the true crime community is his autism diagnosis. His team says he has it. They've said it explains some of his affect when he's sitting there taking in information in the courtroom. I've got a clip. Let's watch.
Sure.
Brian's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position, and that means nothing. That's just how Brian is. We seek to prevent the state from using those kind of characteristics against Brian.
Okay, and so the judge said if he testifies, it's fair game. What do you think, Professor? Is that the right ruling on that?
Yeah, I think that it is. This is something that has not been known about him, and suddenly it kind of materializes as we've continued to progress toward that oncoming date in August. It's fascinating relative to this idea that he may be, diagnosed with autism. Well, I mean, nowadays, you can almost look at it like, well, take a number. That diagnosis is made wide and far now. So what does that actually mean? And the fact that he's not allowing this in, without Brian Kohberger going under cross-examination or direct, is not surprising, because why should the prosecution have to attack this bit of information when it's something that's kind of come to the game very, very late here?
Right. Professor, one last quick question for you, please. No saying touch DNA is going to be the rule this time around. What do you think about that?
I'm amazed. I feel like that every time there's a new motion, I'm going to have an English language lesson, where she's going to be diagramming sentences, and we're going to be talking about gerunds and everything else. This idea of excluding this term, pardon me, I think touch and contact. So what you're actually saying is transfer DNA that came off of somebody or something. I guess what she's getting to is that if you say touch, that means that you put your hands physically on them. And this is fascinating. I've not seen this come up in a trial before. The fact that they're going to exclude that term is I wonder what kind of weight this is going to bear on down the line, even beyond the Idaho 4 trial. You know, are we all going to have to change our vernacular based on this case? Because, you know, we can't say trace, we can't say contact. There were a couple other terms like that she's fought to try to keep out of court. And so now we're kind of dictating the language at this point in time. Kind of interesting, to say the very least. And the experts that get on the stand, which there will be some, are going to have to be very careful with how they word their descriptors.
Oh, that's a good point, too. Yeah, the rules apply to everybody. Professor Joseph Scott Morgan, thank you for all of that. We're not going to let you go just yet. We've got more questions for you, please. After the break, we're going to talk about the case of Crystal Rogers. Did something go wrong? We're talking about the ordering of the trials for these defendants. And opening statements coming up in just minutes in the retrial of defendant Karen Reed.
This is not normal. You normally do not tailgate a murder trial.
Were you all trying to blame Lucky Loughlin for it?
I hit him, I hit him, I hit him. We support the O'Keefe family.
No, you're dodging the question, David. You're dodging the question.
I'm not here to be interviewed. You've agreed to be interviewed. You told police you shot him twice in the head. It sounds like you lost control of yourself.
Not at all. No, not at all. I could have killed everybody in that building, and I didn't.
You think you should get some kind of credit for not killing people?
Interview with a Killer. New episode, Sunday at 8 on Court TV.
I'm working very hard on bringing justice for my daughter, and it is coming. It is going to happen.
What do you think happened? I'm shocked. I do not know. I don't need an attorney. I haven't asked for an attorney. I don't need none of that. I'm innocent.
Yep, that's him.
Where's Crystal Rogers?
Now for what's tipping the scales, we're talking about one of the murder suspects in the case of Kentucky mom Crystal Rogers. He's set to go on trial next month despite a delay, a request, I should say, from his defense team to delay the trial for a second time. Stephen Lawson was in court last week. He, along with his son Joseph, and Rogers' boyfriend Brooks Houck, all three of them charged in connection with her death. Now, Crystal Rogers disappeared in July of 2015, has not been seen since. Here's Houck being interrogated by police about their relationship.
Had you and Crystal ever talked about breaking up? I mean, obviously we have fought just like any other couple, but in the last several years, I mean, it's came up, but we've always found ourselves together moving forward.
So here's what has us scratching our heads. So look at this. Stephen Lawson's trial starts on May 27th. His son, Joseph Lawson, is going to be tried jointly with Brooks Houck on June 24th. Now, the Commonwealth alleges that Brooks is Crystal's killer. That's what they're alleging. They're alleging the father and son, the Lawsons, conspired in this plot and engaged in some tampering. Those are the allegations against them. But look at the dates. So Stephen Lawson, the dad, his case is set to go first. We know that it was severed from the other two. The court found that there would have been prejudice to the others if his would have gone with theirs. Okay, guess we understand that. But if you've got the killer, and they say they do with Brooks Houck, why don't you try him first? What's this about? I couldn't think of two better people to help us work through these questions than Joseph Scott Morgan and attorney William Ehlenfeld. All right, so William, boy, you have a ton of experience. You're a former United States attorney, former state-level prosecutor, a criminal defense attorney in the private sector. What in the world is going on? If they've got the killer and they say they do, why are they trying someone who had a lesser role in this first?
It's unusual, Julie. You know, I've had cases where, homicide cases where you have multiple people involved. Had a triple homicide case, a tragic case in West Virginia several years ago, and we had a couple of people who actually were the triggermen who pulled the triggers, and we had some conspirators and co-conspirators who didn't have as much of a role as the people who pulled the trigger. And we wanted to wrap up the cases of the people who had lesser roles as quickly as we could. And I know in this case, the prosecutor discussed reaching a deal with Stephen Lawson. And Stephen Lawson's not the person who they allege committed the murder. He helped to move the car and to tamper with the evidence and to conspire, but not to actually be the one who killed Crystal Rogers. So if it were me, I would want to have his case wrapped up. I'd want him to be on Team Commonwealth. I'd want to have him testifying for me at trial. He's already made some very valuable statements to the prosecution. They're going to hurt him, but some very valuable statements to the prosecution. And so I'm not quite sure why it's going in this order. I would want Stephen Lawson under a plea agreement, cooperating with the Commonwealth, and being my star witness at the trial of Brooks Houck and Joseph Lawson if he also has his charges remaining pending.
Yes, that makes so much sense. And William, walk us through kind of practically. So let's say you arrive at the plea agreement. Would you leave the sentencing unagreed to, right? How do you do it? Would you kind of walk us through how this might go to get him to do what you hope he will do?
Sure, and I should say that the Commonwealth did talk about reaching a deal with Stephen Lawson, and they felt he was not completely truthful with them, which is why they didn't reach a deal. At least that's what's been released publicly. So, yeah, that's right, Julie. As far as the process, you would reach a plea agreement. He would come in and he would plead guilty. Sentencing would be deferred until the trial of the other two were to take place. So you would want to make sure that he would cooperate and testify truthfully. Of course, the defense attorneys at the trial would be able to cross-examine him and say, isn't it true that you have a deal? Isn't it true that you struck a deal with the Commonwealth and they expect you to testify in a certain way? And then you would hope that Stephen Lawson would say, look, I'm just up here telling the truth. I'm telling you what happened. Then the state would have to put in other evidence to corroborate it so that he would still have some credibility as a witness. But that's what you would do. You would have him plead guilty. You would have him testify. He would be sentenced later. And if he didn't cooperate or if they felt that he was untruthful on the stand, then the judge could consider that at the time of sentencing.
William, thank you so much for that. We're going to watch for that. I feel like just something doesn't add up with this case. So thank you for that. We'll see if that in fact happens with this guy. Joseph Scott Morgan, you have done so much research on this case. You have podcasted about it on your show, Body Bags. It's a troubling story, we know, Crystal Rogers, and it seems like we've got more questions than answers. What troubles you the most about this one?
We don't have her mortal remains. Is one of the major problems. As you lawyers say, the corpus delicti. And that's a problem, I think, particularly, when you begin to think about, juries want to see the body. And I'm not saying that from a grotesque standpoint, but if you're going to charge someone with serious offenses like this, it helps the prosecution if they can demonstrate that, we have remains here, this is what happened to them. Which is very powerful. And in this case, you're absent that.
Right.
It becomes almost speculative.
Do you have any theory, Professor, on this one as to what might have happened to her remains?
Yeah, I think the proximity to the road, to the Bluegrass Highway there, I think, and the property, everybody's familiar with it. And we also, let's don't forget Crystal's father, too, which, again, his death took place in the woods out there, and and it all seems to revolve around that area.
Right. Tommy Ballard, thank you for bringing him up, Professor Joe. Here's what we're going to have to do. We're going to have to plan another segment. It's a great excuse for us to get you and attorney William Ehlenfeld back to dig into that, because Tommy Ballard deserves justice. He was advocating for his daughter, and his murder, as you said, still unsolved this morning. Big thanks to Joseph Scott Morgan and William Ehlenfeld, and to you at home for being with us here on Opening Statement.